Good afternoon, everyone. Thank you so much for joining us today. For those of you who don't know me, my name's Amie. I'm an immigration solicitor. I practice with ATLEU, the Anti-Trafficking and Labour Exploitation Unit, as a consultant solicitor and training lead. And in my other role, I am a consultant for DG Legal on all things immigration, legal aid and legal compliance related. I'm joined today by Chris, who I'm sure many of you will be familiar with. Chris is a partner at Parker Roads Hickmott Solicitors, a very experienced immigration solicitor, and also sits as a fee-paid immigration judge in Manchester. And I thought it would be great to have Chris join us today so that he's able to give us his insight as an experienced practitioner, partly because he has witnessed these cases as an immigration judge, but also because he has been part of the Tribunal's online pilot system since its inception and is therefore able to give us some tips and tricks on how the system works. Part of the reason why we felt it was important to do this webinar today is simply down to the fact that the Tribunal now has made the use of the CCD system mandatory as of the 22nd of June. And particularly from my experience working with immigration practitioners through my work with DG Legal, there seems to still be a real lack of awareness and understanding about the system, about how it operates and when it should be used. So we felt that providing a detailed webinar such as this, along with some notes to accompany it, which will be available to you all afterwards as well, would really help raise that awareness and act as a guide to people when they're lodging their appeals through the system. I also just wanted to highlight before we start that this webinar is being developed and presented as part of a series for DG Legal. The following two webinars will be on the funding under the new Stage 2C, and for that reason we're not going to be covering any questions or issues on funding as part of this webinar today. I have received quite a number of questions about funding in advance of this webinar, and I will respond to all of those queries either directly or as part of the FAQ document that we're going to put together after the webinar and circulate. But as I say, today we're not going to be able to focus too much on the funding side of things. The other webinar as part of the series that DG Legal will be running is about the preparation of the ASA, and dates and details about those further webinars will be circulated in due course when we finalise the dates. Along with that, we're doing various other webinars such as a guide to peer review. We have one on the crime category next week and the immigration category in a few weeks' time. If you do want to be kept informed of those forthcoming webinars, please either drop me an email or ideally have a look at the DG Legal website and sign up to the mailing list so that you are kept up to date with those details. Finally, I just wanted to say, as I briefly mentioned, the questions that we have been asked in advance of the webinar, we will try and cover in as much detail as part of the session as we can. Where we're not able to cover everything, we will compile an FAQ document, circulate that to all attendees, and we'll also post it on the website as well. So hopefully we will eventually cover absolutely everything that people have asked us to, and just really hope that it's going to be a useful session for everybody. So I'm going to talk to you a little bit about registration on the new system myself and how to actually lodge the appeal. And then I'm going to hand over to Chris, who's going to talk to us about building a case online and give us his tips and tricks in terms of how the system actually operates. So I'm sure you're all familiar by now that the online system became mandatory from last Monday, the 22nd of June. And this was made clear in the practice direction statement that came out. And all immigration appeals should now be lodged using the online system unless it's not reasonably practicable to do so. What constitutes not reasonably practicable will be down to the Tribunal to determine. So if for any reason when you come to lodge an appeal you feel that it's not appropriate and it's not reasonably practicable for you to do so using the online system, you will need to explain why that is the position to the tribunal, and they will make a decision as to whether or not it's acceptable to not use the system or whether you will be directed to use the online system as in the other appeals. The types of appeal which the tribunal accept would not be reasonably practicable to use the online system are those that I've set out on the slide here under the bullet points. So those under the EU exit regulations, out of country appeals, detained appeals where the appellant's in detention, those who are unrepresented, or appeals where your appeal is linked to another appeal that's been lodged at the same time. So other than those categories, for any other appeal, as of last Monday, it needs to be lodged online using the system. These are the bits of information that you really need to be familiar with. The Presidential Practice Statement of Michael Clements, dated the 11th of June, and the associated annexes. If you haven't read those yet, please do look at them. These bits of information in this practice statement supersede any previous directions. So the bulk directions that were being issued from the start of the pandemic are no longer in force. We now need to look at the practice statement and the requirements contained in that to dictate what we are supposed to be doing now, and it's not those bulk directions that you need to have reference to. When I say that, it's important because those practice directions, those bulk directions actually refer to things like the limit of a 50-page bundle, and that's not applicable anymore. It's not something that you need to be concerned about. There is no limit on the size of a bundle that we've come across as of yet on the online system. So the first thing that you need to make sure that you've done is actually register the firm an account on CCD. I imagine that most of you have probably done that by now, but I'm going to quickly go through it for those who may not have yet done so. Registration is done usually by the main point of contact at your firm, and that role is known as the super user. So the super user has the authority to change the details about the firm and to invite all users to have access to the online system. When the super user logs on and starts to register the account on CCD, they will just be asked to provide details about the firm and their own email address and details, so that then the system can generate an email for them. They log on and register their account, and they then have the facility to invite other users within the organisation. It's quite straightforward, and personally I think that it's quite a user-friendly, intuitive system. It's quite obvious for the super user. Once you're logged on, you can see that under the option to manage the organisation, you can clearly see the option to add or invite users. When you click on that, you're taken through this screen which asks you for the information relating to each user you wish to invite. It's basically just their name and their email address. There's different types of permission levels for users that the super user can allocate, managing cases, managing users, or the organisation itself, and depending on what authorisation you want the users to have, you can choose that accordingly. Once the super user has invited a user to join the system, the user will just receive an email into their designated email address to click on and set a password, and they will then be able to log in and access the system and use it to lodge and manage their appeals. One of the things that I wanted to mention at this juncture is where you go onto the HMCTS system to actually register, you'll see that it says you have to have a fees account in order to use the MyHMCTS system. That's not entirely accurate because, as this slide clarifies, the Tribunal does not currently have the facility to accept payments via the fees account system. So even if you set up a fees account, you can't pay Tribunal appeal fees through it at this moment in time. It's a bit of an odd situation in the sense that you lodge your appeal in the normal way, irrespective of whether a fee is payable or not. And if and where the Tribunal determines that a fee is payable, they will contact you to ask for that fee to be paid in due course, in the same way that they were previously asking fees to be paid. I think with the fees system, the idea is that the system will be developed so that it will be possible to pay tribunal fees through the fees account, but that hasn't as yet happened.
Amy, could you guys jump in for 2 seconds?
Sure.
One thing, I don't know if you've noticed in the chat, some people are struggling to hear, your mic seems to be sort of a bit crackly.
Oh, is it? Oh, I'm sorry.
But just if I can add on about fees, interestingly, I was, because I've been consulted a number of times on the development of this system, just to sort of trial run things. I actually contacted yesterday by MyHMCTS about the new integration of paying fees and the new fee page, which is going to be incorporated in CCD. It's not going to be up and running for a number of weeks, but hopefully I'll get to sort of look at it sometime next week to see how it works. And the plan is to integrate a system for paying the fees on CCD. So hopefully that will come in the not too distant future. So we will let people know when we have a bit more information.
Great. Okay. So just giving you a brief overview of what the system looks like. These are the 5 main tabs that you will see: the Overview, Appeal, Appellant, Documents and Directions tab, and the progress bar in green, which shows you which stage you've reached as part of the appeal that you're managing. It's also useful that you have the Do This Next box, which will tell you the current stage that you're at and what you need to do next, if anything. We've tried to put on here an example really of what the progress bar looks like and all the stages that you would move through as part of the system. We've literally replicated this from the online system just so that you can see it as a reference to the stages that you will need to pass through. So the first thing that you need to do once you have a decision that you need to appeal is to create the case on the system. As I said, I think it is really a user-friendly system. It's quite intuitive and it's pretty obvious when you log on what you need to do. When you're creating the case for the first time, you will choose from the 3 drop-down boxes and select the appropriate categories from the jurisdiction, the type of case, and what you're wanting to do. So in the beginning, it will be to start the appeal. Once you've selected the initial stage of opening the case, you'll be asked on several pages about the details of your case and your client. You'll notice here on this screen where they're asking for information about the client. This is basically to verify that the online system is the correct forum for the appeal. So you'll see that those boxes there relate specifically to the points that we mentioned earlier, where the tribunal says that the online system will not be appropriate or not reasonably practicable. Choose the select the appropriate ones and click on continue. It will then take you to the page where you are basically putting in details about the deadline on which you have to submit the appeal. So they ask you for the Home Office reference number and the date on which the Home Office decision was sent. So as you can see, that's for the purposes of calculating whether or not your appeal is being lodged within time or not. Basic details relating to your client have to be input, so name, date of birth, nationality. They're all very simple to fill in and literally click next, continue. It's very obvious which bits you need to fill in and which bits you don't. Here is the information box for your client's address that will be held on record by the tribunal. We have had a question in this morning about there being some difficulties where the appellant does not have a fixed address, and it's been quite difficult for the tribunal to progress without actually having a fixed address. Again, that's something we're going to respond to that specific question as part of the FAQs, because the system should allow for you to have no fixed abode but a care of address inserted in there. The next page is simply for your client's contact preferences, Do they prefer correspondence by email, text message, and obviously via the representative for any information that can be passed on through CCD, the system itself? One of the main key differences really with the CCD system is that you don't have to draft or upload your own grounds of appeal, which is quite a different system to what we're used to traditionally. So in here, you would simply start your appeal by selecting the type of appeal that it is and moving forwards. The option to select grounds of appeal then appears dependent on the type of case that you are selecting. But yes, it's quite unusual to not have to draft and submit your own specific grounds of appeal on CCD. They will also ask here whether you or your client has appealed against any other immigration decisions and whether there's any new matters that the tribunal needs to be aware of. So again, you need to make sure that it's raised at this juncture if there are any new matters that haven't previously been notified to the Home Office or to the tribunal prior to the decision being made. Once you've submitted all of your information, you'll be taken to an overview page which gives you a summary of the answers and the information that you've actually put in. Read through that to make sure that it's accurate and that there's no changes that you need to make before you submit your answers. In the event that your appeal is submitted out of time, you'll see this big red warning box tell you that it's out of time. Where that happens, you will have the option to give an explanation as you would under the traditional method to say what the reason is for the appeal having been submitted late and put forward representations as to why it should be allowed to proceed. The tribunal caseworker will then have a look at what you say and make a decision as to how the appeal will proceed in the event that it's determined to be out of time. And a decision will be sent to you via the online system as to how it will proceed from there. Decisions and directions that are received from the tribunal will appear in the Directions tab, which is one of the main 5 tabs that you see on the system. And that's directions that are issued both to the appellant and to the respondent, so you can see exactly what is meant to be happening next and what the tribunal is waiting to happen. And it's separated into directions for the appellant and directions for the respondent on there. And so you can always log onto that tab just to see what's going on and what stage we're at. Chris, do you want to take over from me here in relation to the case building section?
Yeah, that's fine. Not a problem. I hope you can all hear me okay. Please put something in the chat if you can't. I'm not quite sure what I can do about it, but yeah, I will try my best. As Amie showed you, there is the progress bar, which will tell you where the case is and how it's moving along. The initial directions that you will get will be for, well, first of all, to the respondent to upload their bundle, so the Home Office bundle. And then once the Home Office bundle has been uploaded, you will then get a direction telling you to build your case. Just in terms of directions, although they are shown on the relevant tab on CCD, they are emailed to the whoever sort of lodged the appeal with the correct email address. So you do get an email warning of any directions. You don't have to keep going back and checking CCD every day. And in terms of case building, this is done 28 days after the respondent has uploaded their bundle, or 42 days after lodging the appeal, whichever is the later. So you have to be aware of your deadlines, but these will all be detailed in the directions. Case building is how CCD describes the part of the case where you're putting together your appeal skeleton argument and your appeal bundle. We won't be going into sort of detail about what an appeal skeleton argument involves, because as Amie said, there will be sort of further webinar to deal with that particular issue. But I'm sure most of you will have seen what that's come out of the tribunal in relation to an appeal skeleton argument. And this is where on the CCD you have this tab and where you can then go into build your case, and it's where you can upload your appeal skeleton argument and also your appellant's bundle. You have to it's a much more, I would say, straightforward system. The fact that you can upload it directly, you don't have to do numbers of different copies, print them out and send them anywhere. You're not constricted by size if you're trying to sort of email things. It's just uploaded directly into the CCD. The important thing is to make sure that you describe everything accurately, which is the important thing when you're uploading any of your documents. So what you have to do is put your bundle together and make sure you describe it as the appellant's bundle. And I think it's something that we looked at earlier, one of the earlier slides, in the same way that when you're submitting your appeal, there are lots of different stages to go through. You can upload things, but without submitting them. So you have to make sure you remember that you go through the process of uploading, checking it's all there, and then remembering to go back and submitting it. Uploading isn't the same as submitting, and it's quite sort of keen, the system, to make sure that you don't do anything that you don't mean to, and as these slides show, you have to go through it, save your upload, and then submit it. And it's really key that you don't forget to go through each stage. Now, one of the advantages of CCD in your case building is that you do get a reasonable amount of time. It's at least 42 days from when you lodge the appeal, so you've got at least 6 weeks, at least 4 weeks after you get the Home Office bundle. So in most cases, you should have sufficient time to be able to prepare everything that you require. But of course, we all know that if you need expert reports or there are other reasons, you may need to apply to get more time to build your case. And at present, the way it works is that you would email the tribunal caseworker directly. I think there is some hope that eventually you will be able to sort of communicate directly with the tribunal caseworker via CCD, but at the moment you have to do it as a separate email. So what you do is you would just say email with your explanation about why you want more time. My personal experience is that thus far the TCWs have been very good about requests for extension of time. I'm talking about sort of pre-COVID. Obviously during the pandemic, it's been slightly different and lots of things have been granted for many reasons. But even before that, if you came up with a sensible reason why you needed more time, I certainly have never had anything yet knocked back. I think one of the earlier slides showed that once you have uploaded everything, there's the documents tab, which will list all of the documents, Home Office and appellants, in one place. And once you've built your case and uploaded your ASA and your appellant's bundle, that's when the Home Office have to actively review the case. They have 14 days after uploading all of that to review everything. And that's sort of the key part of the case. Your appeal skeleton argument has to be focused on why the decision was wrong, and hopefully, the idea is that the Home Office will hold their hands up and say, okay, we accept we've got this wrong. They may withdraw the whole case, or they may in their review say, yeah, okay, well, we'll concede these issues. That's the purpose of the review. Once you've had the review, you can upload more documents. When the system first started in the pilot, it didn't have that option of allowing you to upload additional evidence, but it does now. You can upload additional evidence right up until the day of the hearing if you really want to. You have to explain why you're doing it now and what's changed. And as some of you may know, I do lots and lots of Iraqi cases. So I prepared dozens of ASAs and appellants bundles before SMO came out at Christmas. But those cases hadn't been listed for hearing, so I had to upload new bundles, new appeal skeleton arguments dealing with the new country guidance case. So it does allow you that facility, which I think is helpful, because I think people have been worried that if it takes 4 to 6 weeks, sometimes longer, to get a hearing date after the respondent's review, things can come in at the last minute. But I say you can still upload them to CCD. The big difference with CCD and the online procedure to the sort of the business as usual cases is that you don't get a hearing until you're all ready, that every party is ready to proceed to a hearing. The idea is that, you know, it avoids unnecessary adjournments and so on. So once you've uploaded all your evidence, the Home Office have reviewed everything, you've uploaded any additional evidence, then you'll be asked to submit your hearing requirements. It'll be necessary to set down what type of interpreter you want, whether there are any special requirements, whether you have a vulnerable appellant, how many witnesses, so on and so forth. But there's on the timeline, it asks you to submit your hearing requirements, and it asks you a number of questions so that you can submit everything that you need in terms of your hearing requirements. And again, then you have to submit that so that the case then will be listed for a hearing. Once the TCW accepts that it's ready for hearing, they will put together a hearing bundle. They stitch everything together, all of the Home Office bundle, the appellant's bundle, the appeal skeleton argument, any additional documents. Different hearing centres seem to deal with it in different ways. In the TCWs in Manchester seem to provide a summary page at the beginning of the bundle, but I haven't seen that in Bradford, so I'm not quite sure, you know, whether that's why that is, or what the reasoning for it is. Personally, I didn't think that the summary was particularly helpful always, but you know, sometimes it was. So whether that will get rolled out at other hearing centres, I don't know. We shall see. But I say you then get one huge bundle, which is in your documents tab on the CCD, and that will be the bundle that all the parties will use at the hearing. As I say, it's a very big and sometimes it's slightly unwieldy document, but if you have reasonable sort of PDF software, they're easy to view. You can download them. You can, if you're a solicitor, you can email them or share them with counsel if you're instructing counsel. But it's the important that you at the hearing to be aware that everyone will be working from that same one consolidated appeal bundle. Then obviously you have your hearing, which is very much like any other hearing, apart from the fact that, you know, there isn't, or there shouldn't be, any paper hanging around. You're all looking at screens and everything is done online. And then you get the decision, which is now going to be served via CCD. It gets uploaded there. Again, like anything, when there's any action, you do get an email telling you that something has been uploaded, and that's where you will find your decision. Again, you will find some decisions just look exactly the same as you would get them normally. There is circulating within the judiciary a sort of pro forma, which some judges like to use, and it looks slightly odd because it's basically cutting and pasting parts of the consolidated hearing bundle, and frankly I think they're more difficult to read, but it's the decision that matters, and that's uploaded to CCD, and that's where you will find it. And fairly recently they've added in the ability to make your application for permission to appeal to the upper tribunal that you the application you make to the first tier can be done via CCD as well. But again, that will tell you on the next steps stage, and we'll let you know what you need to do from there. Am I talking about timescales, Amie, or do you want to?
By all means, carry on. I'm just trying to answer some questions.
Very good, very good. Keep typing then. As you see, these are the timescales. I've mentioned some of them as we go through. It's like 14 days to get the respondent's bundle. That's the first direction that's issued. My experience is that in nearly every case, the respondent's bundle is uploaded well within those 14 days. I have had a few cases where it's taken longer. And interestingly, the TCWs are checking the respondent's bundle. I do lots of fresh claims, and if in the respondent's bundle it doesn't have previous tribunal decisions and so on, the TCW will reject it and tell the Home Office to go away and file a complete bundle. So it's good that these things are being monitored on both sides. Once the respondent's bundle has been provided, 28 days to build your case, or 42 days after the notice of appeal was lodged, whichever is later. I'm not sure whether this is still a teething problem, but initially, the first direction that was automatically generated by CCD would sometimes be wrong. So, for example, if the respondent uploaded their bundle, the day after you'd lodged your appeal, then the direction from CCD would say that you had 28 days from then to build your case, but that's not correct because it's 42 days. So you always get that 6 weeks. It's not going to be 4 weeks and a day or 2 days if the respondent upload their bundle early. You always have that, at least that 42 days. So remember that, and it's something to check. And like I said before, once you've built your case and uploaded everything, then the Home Office get 14 days to review the case and file their review. Thus far, I haven't had a case where the Home Office have failed to meet that 14 days. But I have seen differences in the standard and the quality of the responses from the Home Office. The reviews in Manchester, in my experience, have been much better than the reviews undertaken by the Home Office in Leeds. Whether that's just because they've got more experience, because Manchester were a pilot doing it first, or just different people with different views, I'm not so sure. We have to wait and see. But it is helpful to have a review so you know what the Home Office position is, and in theory, they shouldn't go behind that again. So Amie has helpfully got together some stats for us from her research via DG Legal. And I think what most people are interested in is the withdrawal rate, which is still hovering around almost 20%. So, 1 in 5 almost appeals being withdrawn, and the Home Office has, in every meeting I've been to around this, always said they will only withdraw to grant. Whether that will change when more appeals are submitted, who knows? But I hope not. But it is quite a relatively high amount. Whether that continues, we shall see. Because obviously, as you can see, the number of appeals that have been reviewed is quite low. So once everyone starts lodging their appeals and there's a much greater volume, whether the Home Office will spend as much time reviewing them and be as willing to withdraw, we shall see. That's 69 hearings, and I'm sure there'll be some more going forward.
Just to jump in at that juncture, Chris, if I can.
Of course.
These are not DG Legal statistics. Just don't want anyone to think that that's come from us. It hasn't. This is the Tribunal's own statistics that I've pinched from some training slides that they used in Birmingham, I believe, last month. So I understand that these statistics include everything since CCD has been in operation, so including the pilot. So yes, I suppose there's been quite a lot of reviews, but I don't think that that is particularly many withdrawals. Obviously, quite a high number where in fact were upheld rather than withdrawn to grant. Obviously, it would be helpful if the Home Office do undertake meaningful reviews at that stage, and that we're saved having to go through an appeal hearing for often vulnerable clients. But these statistics obviously include the pilot data, where I understand, and Chris will correct me if I'm wrong, that there was a specific team within the Home Office set up to look at this. So I'm not sure whether I think that the rate of reviews and withdrawals to grant will be as high. I'm not sure that the Home Office have the manpower to do that, but hopefully with time we'll work towards that. So I think in summary, I think we can both add bits and bobs to this one, Chris. I think there are pros and cons to the online system. I thought initially that I would be hugely against it. Maybe I just don't like change. But actually, having looked at it and used it, I can see that there are some real pros with it. If you're like me and a bit of a technophobe and a bit wary of a new technical online system, don't be nervous, because it's really easy to navigate and it is really intuitive. And I think through using this system where you're able to, you'll realise that actually it's a lot quicker to lodge appeals. It's much easier to have everything all in one place. You're not needing to print numerous bundles and waste huge amounts of paper. So it is going to be cost effective as well. I think we've just got to get used to it ultimately. I think it's a new system, and it's come as a bit of a surprise to a large majority who didn't know about the pilot system. But actually it's a good system, I think. It's still a beta system, so they're still making changes, it's still in development, and I do think that within the next phase of developments they're likely to make changes, and we're going to see those changes over the coming months, and hopefully it will be more user-friendly and integrate, as Chris was saying earlier, with the fees account. That would be really helpful. Yes, from a cons point of view, the system does allow longer periods of time to take specific action, so it's a longer appeals process. It's different in the sense that you're not lodging specific grounds of appeal, and you can't say at the beginning of your case whether it's private or legal aid, whether you're paying a fee or not paying a fee. So that bit's yet to sort of be ironed out. Obviously, we're all familiar with the issues that there are over the ASA. What is an ASA? What does it look like? How long is it going to take us to do a meaningful ASA? Do we have appropriate funding? That's all for another webinar. So I think it's a mixture really of some really positive things and a few teething issues that probably need to be ironed out as we all get used to using a new system. What are your thoughts, Chris, in terms of pros and cons?
I think I love the fact that there's no paper. It always used to bug me that we had to serve paper bundles on the tribunal. I thought it was ridiculous. And the cost of printing and then posting hard copy bundles, if you're doing hundreds and hundreds of appeals a year, adds up very quickly. The fact that it takes 2 minutes to lodge an appeal makes life a lot easier. The fact that the case doesn't get to a hearing until it's ready, although that it means that you're waiting longer, which sometimes appellants don't quite understand. But the fact that barring unforeseen last-minute circumstances, when you get to a hearing, it's going to take place because everything's been ironed out and everything's ready to go, I think is really helpful. I think that part of the issues, and I know we're not talking about funding today, but the cases do take longer, and obviously at the moment we're not getting really paid anymore. There are more stages. Because it takes longer, you need to see your client more. You have to review the Home Office review. Sometimes you'll need to get your client in to go through that review. Often you will need to prepare additional evidence. So these are sort of extra steps in the case that you wouldn't have had to have done before, which you're not getting paid anymore for, so that's frustrating. But in terms of, if you ignore funding, I think that the system is much more efficient, and I think it's a good way of progressing cases, and it works well. I like the system. As Amie says, it is still sort of beta, and they will accept feedback on things that are not right, if there are anything that you notice on it. One particular thing that really frustrates me about it, you have on the first screen, when you've lodged a number of appeals, there's sort of a search facility, so that you can search for your appeal, whether it's by the appeal number, the client's name. There are all sorts of different fields at the stage the case is at. But really annoyingly, rather than the stage the case is at just defaulting to any, it defaults to appeal submitted. And I've been telling them this for about 6 months, and they keep saying, yes, we're going to amend it, but it hasn't yet. So there are slightly annoying little quirks like that, but they do listen when you say that that things are wrong, and they will try to change them.
Yeah, I think one thing we've forgot to mention as well, which I think is really important, is where you open a case, a user starts an appeal, the directions and all correspondence is sent to that specific user. So there is a facility on CCD to share the case. And I think that's really important, because unless you remember to share the case with a supervisor or another person within the organisation, if you have a buddy system or something like that, in the event that your user is off sick or on furlough or unavailable, then no one else within your organisation can actually access their appeals on the system. So I think that's probably something that they need to have a look at, and as users you need to be aware of, get everybody to share their cases, and that's on the main screen under the, I think it says there's a drop down box that says do this next, is that right, Chris?
Yeah,
it just gives you an option to click on share case.
In the top right hand corner there's a little box that says next steps, and it's got a drop down, and it's got a number of things that you can you do from there in your next steps. But one of them is, say, sharing with a colleague, and this is interesting because I only found this out during the pandemic, and having furloughed a significant number of staff. I'm our firm's super user. I'd set everyone up, and so I assumed that I could see all of the appeals that were lodged by PRH. And I had these discussions with the tribunal, and they kept saying, you haven't dealt with this appeal. And I said, I can't see it on my list. It's just not there. And we were sending the technical team screenshots and so on and so forth. And they said, no, we can see it. Why can't you? And it was only then that they explained that the super user, the admin, can't actually just automatically see everyone's cases. It's only if they've been shared. And so this is a lesson we learned. I had to WhatsApp all of my staff who were furloughed and ask them for their login details and how to log in, and then share them. But it's there that for supervision purposes, that any appeal lodged by an individual is then shared with their supervisor, their buddy, whoever, or else the emails about directions and so on will only go to that individual, and that individual will be the only person that can see that appeal. So it's a bit of a flaw in the system, but as long as you know and get all your team to share all of their appeals with as many people, you can share it with as many people as you want, I think, but at least a supervisor, a buddy, someone else, then that's what you've got to do.
Presumably, Chris, just a thought, could you share with a generic email address perhaps that several people have access to?
I think you'd have to set up the generic email address as a user. Yeah. But yes, if you set up, gave that person a generic name, and then set up that generic email address as a user, then I think that would work. Can't see any reason why it wouldn't, put it that way.
Mm-hmm. Okay. So we've just got a couple of questions that have cropped up that we'll answer now because we've got time to do that. Chris, can you see those two answers that we've currently got about the scope to amend grounds of appeal at a later stage, and how would we go about doing that?
Good question. Because obviously the only grounds of appeal are the statutory ones in Section 84. I suppose if you had forgotten at the beginning to tick one of those boxes, or if you decided that it became an issue later on, I would assume that the same as with anything, that you'd have to email the TCW. I say it's slightly frustrating that it's not as yet a totally integrated system, and if you want to ask any questions or query things, you can't at the moment do it through CCD. You have to email the TCW. So if you got a human rights appeal that you found out later that there was a protection issue, then I think in terms of whether that was a new matter or not, or whether you were just amending the grounds, I think you'd need to email the TCW.
Yeah. Okay. So I think in summary, it just, as we've kind of said, funding aside, and grumbles about that for a later date, the system itself is actually a good one, and is user friendly and is cost effective. So hopefully with a bit more development and a few useful changes, it will be even more useful to us as representatives to use and streamline things a little bit for us, hopefully. Is there anything that you wanted to say, Chris, that we can add that we've not covered already?
I don't think so. I think it's daunting having a new system and being told without much notice that it's mandatory to use it. So I can understand why people are daunted, and I can understand there are lots of concerns about the ASA and funding and so on, which are a separate issue. But if you're just looking at CCD as an online system for lodging and progressing appeals, it works well in my experience. It's easy to navigate, it's fairly intuitive, and it is simple to use, and it saves a huge amount of paper and postage, and I find it an easy system to use and to progress appeals with.
Yeah, great. Okay, well, amazingly, we've whizzed through a lot faster than we anticipated. We thought it would be approximately an hour, but we've finished just slightly short. I just really wanted to say thank you so much to everyone for having joined us. I know we've got a huge number of people on the call, and it's great that we've been able to reach so many people. So thank you very much for your time. The other thing was just to say we will be emailing a copy of the notes around at the end of this, and a copy of the recording and the slides will be available on the website. I believe also there is a survey that will come out to you as well, and we'd be super grateful for any feedback that you can give us. And again, just please bear in mind the additional webinars that we're running at the moment on the peer review, the funding and the dreaded ASA. So please do look out for that and sign up for the webinar if you're able to do so and if you're interested. And I think that we've answered as much as we can, but we'll cover anything that's come up in the Q&As that we might have missed afterwards, if that's okay. Happy with that, Chris?
Yeah, no, sorry, I was just trying to answer a couple of questions
Yeah.
So I'm glad that people are using the chat box. It's been very helpful. I'm sorry if there are things that we've missed, because of, you've all been very interactive and sent us lots and lots of different comments and so on. Hopefully we've answered as many of the questions that came up in the box in the middle, and hopefully we've dealt with most of the things that were in the chat. As Amie said, there will be a sort of a Q&A, FAQ, whatever the term is, document emailing out to everyone. So hopefully that will answer any other questions, and we will have covered anything and everything. But say, those of you out there, most of you know me, and it's quite easy to find me. As I've used this system quite a lot, both as a and as a judge, feel free to drop me an email if you've got just queries about how it works and practical questions. I don't have a problem with that at all. But I'm really pleased that DG Legal put on this training, because I think it's really useful that people learn how to use the system now that it's mandatory.
Definitely. just echo that. My email's there, just Amie@DG Legal. Please drop me any queries or questions that we haven't managed to answer that you'd like us to have a look at, and we'll hope to get the FAQs out. I think it's going to be early next week now, but I'll do my best to try and finish them off by the end of the day. Okay, have a great weekend, everyone, and thanks for joining us.
Thanks a lot, everybody.
Bye.